I'm Shehana with and I'm a partner in the Sydney office here at Bird & Bird. I work across the full spectrum of IP and I head up the trademarks group in the Sydney office. I love all things brand related and I have a particular focus on FMCG, retail, education and university sectors. I love assisting my clients with managing, prosecuting, leveraging and enforcing global trademark and design portfolios. I also advise on commercialisation and enforcement of copyright and a parallel area of law which comes up a lot, which is contraventions of the Australian consumer law, so things like misleading and deceptive conduct, misrepresentations, and also passing off.
And I'm Katrina Dang, a senior associate in the IP team based in Sydney as well. Similar to Shehana, I work across all areas of brand management in relation to trademarks, copyright, designs, and commercialisation of IP assets. I've had the pleasure of working very closely with clients in the fashion, retail, and FMCG spaces. It's such an interesting area of work, and there's certainly been some colourful cases recently.
Totally agreed. One which really brought a smile to my dial was the Crumble cookie saga, or Crumblegate. Did you hear about that one, Kat?
Who could have missed it? It was all over social media.
Yeah, it was a hugely funny set of circumstances, but it's worth delving into. So what happened in this situation was there was a pop-up store, what we assumed was a pop-up store for the Crumble Cookie Company in Bondi, and there was a huge line of pastry worshippers lined up along the beach in Bondi, lining up to pick up a famous crumble cookie for the measly price of $17.50 Australian dollars, which is a huge amount if you think about it actually in US dollars, 12 US dollars or 10 euros or even 10 pounds. Now this is a highly unusual thing because these cookies actually would trade for around $5 US. What we heard from punters that managed to get their hands on one of these cookies was that they actually were quite disappointed. They tasted really stale and one vlogger said they tasted just weird. So what it turns out to be is that there were some entrepreneurs that actually flew to Hawaii and purchased some of these original crumble cookies, brought them back on the plane to Australia and decided to set up this pop-up store without authorization. So they were selling these cookies under signage that displayed the Crumble Cookie trademark and associated logo, and they were advertising it on social media and also in various other forms of media, and getting a whole bunch of people to line up and spend top dollar on an old stale cookie that they weren't authorized to sell. Would you have lined up for that, Kat?
Probably not, although I'm not a huge liner-upper.
Well, that makes you a bit unique, I guess. I mean, the funny thing is, there could have been some real strong legal ramifications that could have flowed from this. So they could have potentially found themselves on the wrong end of a cease and desist letter. There'd be claims for trademark infringement from that unauthorized use of the name and the logo. And with that could also be copyright infringement in the actual logo itself. There also could have been claims for contravention of the Australian consumer law, things like misleading deceptive conduct or misrepresentations, that they're trying to show some sort of association or affiliation with Crumble Cookie. And also there could have been claims of passing off. They were trying to trade on the reputation of Crumble Cookie, and that could have led to associated damages. They were really lucky that they didn't actually find themselves receiving such a letter, and all of this was actually settled behind the scenes. It actually turns out to be a pretty good news story in the sense that it ended up being a really, really good publicity for Crumble Cookie. Here we are now talking about the brand, and it's accelerated that company's plans to actually open in Australia. So while in the end there was no huge dispute, it's something that really draws to the forefront potential IP issues that traders should be thinking about before they, engage on what they consider to be a good commercial enterprise. And I just love it because it's so quintessentially Australian to have a whole bunch of pastry eaters lined up near Bondi Beach waiting to spend their money.
Well, the cookie certainly crumbled on a positive note in this case. But speaking of Aussie icons, everybody knows of Ray Gunn for flowing from the Summer Olympic Games this year. Ray Gunn, also known as Rachel Gunn, has recently found herself back in the spotlight, this time in relation to her decision to block the performance of a comedy parody performance titled Ray Gunn, the Musical.
I would have gone to that.
I think many people were disappointed about the cancellation of the musical, which was being produced by an Australian comedian named Steph Broadbridge. Unfortunately, Miss Broadbridge hadn't sought any input or permission from Ray Gunn to perform the musical itself, and when Ray Gunn found out about this production, through her lawyers, she sent Steph Broadbridge a letter of demand, which ultimately culminated in the cancellation of the musical. So what's interesting is that the letter of demand sent to Miss Broadbridge purportedly makes various claims regarding intellectual property infringement to justify the request to cancel the musical. We don't know exactly the contents of this letter of demand, but presumably this included a claim about trademark infringement. Now, in August of this year, Ray Gunn filed 4 trademark applications, 2 being for the wordmark Ray Gunn and another 2 being a silhouette of her infamous kangaroo pose. The marks were applied for in relation to a broad range of goods and services, which included books, magazines, apparel, education, entertainment and cultural event services, dance classes, copyright licensing, computer software, media content, advertising, and retailing of goods. Now, the publication and performance of Ray Gunn the Musical would have infringed Rachel Gunn's trademark, which has been accepted for the wordmark Ray Gunn, since it has been applied for in relation to entertainment and cultural event services. However, Miss Gunn's trademark applications have not yet been registered and therefore are not yet enforceable. So she's kind of jumped the gun a little bit.
Jumped the Ray Gun?
Jumped the Ray Gun a little bit in relation to these claims. But once registered, Ray Gunn could certainly use these trademark registrations in order to enforce her intellectual property rights against other traders who are looking to benefit or trade off of her very infamous name, Ray Gunn. In addition to trademark infringement, a claim could also be made in relation to copyright infringement. Australian copyright law protects literary, artistic, dramatic, and musical works. The recording of her very infamous kangaroo dance may be protected under copyright laws given that it was recorded. However, the name Ray Gunn would not qualify for copyright protection in this particular case. Given that Ray Gunn the Musical was cancelled before its inaugural performance, we certainly don't know the contents of the musical. However, Steph Broadbridge, the creator of the musical, did say that it was intended to be a parody of the cultural phenomenon that has become Ray Gunn. If this is the case, well, in Australia there's a defence to copyright infringement claims, being that of parody and satire, which Miss Broadbridge could have relied upon here if Ray Gunn the Musical was indeed a parody or satirical work. However, what I think carries a bit more weight in this instance are claims made under the Australian consumer law. Certainly, Ray Gunn, if I was Ray Gunn's solicitor, I would have advised her to make a claim that Ray Gunn the Musical creates a misrepresentation that the musical itself, as well as Miss Broadbridge, have the approval or the endorsement of Rachel Gunn, when this was not in fact the case. This could also lead to claims of misleading and deceptive conduct in breach of the Australian consumer law.
That's so interesting, Kat, isn't it? It's a really interesting set of claims, and I just love the fact that she has tried to protect that famous kangaroo shape, which has become so iconic and associated with her. And good on her. It's something that she could possibly monetize and enforce going forward. Speaking of shapes, there was actually a really interesting case this year in the Federal Court of Australia regarding the shapes of coffee jars. Now, in this case, there were 2 coffee producers, one which is called KDE, who sells coffee under the Moccona brand, and then Cantarella, who sells coffee under the Victoria brand. Now, they came head to head in the federal court, fighting over the right to use the coffee jar shape. So KDE actually owns a registered Australian trademark for a coffee jar shape. And because this is a podcast, I'll have to visually describe it to you all. It's the shape is of a cylindrical body with a shoulder at the top of the jar, which slopes towards a thick neck ring surmounted by a 2-tiered circular lid. So essentially it's a cylindrical jar with a stopper lid on the top. Importantly, the dimensions and the colour and the material of the jar is not part of the registered mark. It's just really this overall shape that they're seeking to protect. And they were able to protect it on the basis of use, substantial use. So they actually brought a claim against Victoria for selling coffee in a similar type of jar. And they claimed that Cantarella had engaged in trademark infringement, misleading and deceptive conduct, and passing off. So Cantarella, of course, denied these claims, and then it also cross-claimed, seeking orders that this coffee jar shape mark should be cancelled from the Australian Trademarks Register. So ultimately, the judge dismissed all of the claims brought by KDE in relation to trademark infringement, misleading and deceptive conduct, and passing off, and it also dismissed the cross-claim in regards to cancellation of the mark. So in the end, both parties retained their right to use their respective coffee jars. So I'll just analyse both of the sides of the argument a bit more. In regards to the cross-claim, which was brought by Cantarella, this was dismissed for a number of reasons, but sort of the key reasons to consider are the judge felt that the KDE shape mark had actually acquired distinctiveness through all the use it had accumulated over the years and was therefore capable of being registered. The judge also found there was no fraud or false suggestions or misrepresentations in obtaining that registration, so it was validly entered on the register, and it was also not registered in bad faith. So by all accounts, the trade was a validly accepted and registered mark, so it should not be cancelled. In regards to the trademark infringement claim, it failed for two key reasons. Firstly, the judge held that the shape of the Cantarella coffee jar was not actually being used as a trademark in relation to coffee products. This is because all of their advertisements never actually drew attention to the shape of the jar, and it never asked consumers to use the shape of the jar as a point of distinction from goods of other traders. Importantly also, the jar was heavily emblazoned with Victoria branding all over it on the jar and on the lid. And so the judge held that there was no real tangible risk that a buyer would be misled into thinking that the coffee sold in the Cantarella jar was somehow the same coffee that was sold and sourced from KDE and as part of that shape mark. Importantly, the Cantarella jar had also a very distinct shape which differed from the KDE mark. It was noticeably taller in proportions and had a more compressed neck section with a plain low lid. And lastly, in regards to the misleading and deceptive conduct and passing off claims, again, all of these claims were dismissed due to that heavy Victoria branding that was all over the jar. So that get-up was all over the front, the back, the lid, the base. It was very clearly showing that the product and the source of that coffee was Victoria and not Moccona. So a really interesting case because we don't often see shape marks being enforced in Australia, and there actually aren't many on the register, but it just goes to show how important coffee is to the Australian market. We do love our coffee, and we love that fresh smell of coffee in the morning.
Speaking of the smell of coffee, who doesn't love the smell of fresh flowers? Well, the Australian Competition and Consumer Commission has had a recent end-of-year win against Meg's Flowers Proprietary Limited. It's an interesting case that was brought under the Australian consumer law, and in particular for alleged contraventions of the misleading and deceptive conduct prohibition as well as the making of misrepresentations. So the background of this case is that in May 2023, the ACCC commenced proceedings against Meg's Flowers for allegedly making false or misleading representations that it was a local florist. The ACCC alleged that, despite marketing itself as a local florist, Meg's Florist is an online retailer operating a call centre that receives online orders and dispatches floral arrangements from 11 premises across Australia. They are not, as their marketing and promotional materials suggest, your local mum and pop florist located in each of the towns, suburbs and localities referred to in the 156 websites and 7,462 Google advertisements that had been run or commissioned by Meg's Flowers. Ultimately, Meg's Flowers admitted that it had breached the ACL by making false and misleading representations that it was a local florist when in fact it was not. The federal court ordered that Meg's Flowers pay a penalty of 100 million Australian dollars in relation to this breach of the Australian consumer law. I think that's a pretty hefty win.
A lot of flowers.
That is a lot of flowers.
It really just goes to show from our high-level discussion today that there's a really interesting landscape of IP and consumer law issues in Australia.
Yeah, For sure, and despite Australia being a relatively small market, there's so much activity in the IP space that's happening in this jurisdiction. There have been so many more high-profile cases that we haven't had the chance to discuss in this short podcast. And I certainly think that any international operators looking to expand into Australia in the near future should keep a close eye on what's happening in Australia in order to ensure that they can adequately protect their brand assets.
And of course, we're always here to help.